Migrating to Australia, the podcast, and the best easy listening resource to answer any of your questions and confront any of the issues that can crop up if you are a migrant to Australia, if you're considering migrating to Australia, or indeed if you happen to fall in love with a migrant to Australia. I'm Grant Williams. I press the buttons, move the sliders, hopefully make it sound easy on the ears. and and I'm joined every time we do this by the man with the I've got to say, along with Sam Newman, you've got about the best face for radio that I've seen, David.
Good
David
afternoon,
Bongiorno,
Grant. How are you?
The migration titan. I'm fantastic, David. David is, of course, the principal of DBANDA and Co.
David Bongiorno and Associates.
And Associates. I'm falling into that sloganeering when it comes to referring to business names. And David, we've got a magnificent guest today to talk about a difficult topic. Why don't you introduce our friend Adrian?
It is a difficult topic, Grant. It's mortality and it's wills and estates. And we've got up in beautiful Newcastle, partner at Turnbull Hill Lawyers, Adrian Corbold on the line, and he's an accredited specialist in wills and estates. Adrian, welcome to Migrating to Australia.
Afternoon. Thanks, David. Thanks, Grant.
Now, usually I kick off, but Adrian, Grant's got some questions to get us going.
Well, I've got one, Adrian, and we'll talk about sort of what your specialty entails. But I thought this was a relevant question about most of our listeners are going to be people who have migrated here or people who are considering migrating here. So if I might migrate here in my late 30s, 40s, or even as a parent of children who have established a life here, and I'm of reasonably significant means in my home country, and I have a will that I prepared in my home country, and it divvies up my assets with my dependents, and there's nothing sort of complicated, but it was drawn in Bulgaria or Upper Volta or Bolivia. Is it a legal will here if I pass away here?
Excellent question, Grant. Estate law is, in Australia at least, state-based. So it's based primarily on the primary domicile of the deceased, where they were living primarily at the date of their death and where their assets were held. So in the instance you're giving where, say, your parents come from Bulgaria, move to Australia and make Australia one of the states within Australia, say Victoria, New South Wales, Queensland, their permanent domicile, when in the event they died, what would be looked at is how are those assets, wherever they're held, how are they going to be distributed? Now, each state pretty much has the power only when there's two different types of assets. There's movable assets, things that like a cash that can be moved around, and immovable assets like property. So if someone has property in Bulgaria and they live predominantly in Victoria, or let's say Victoria, the Victorian laws cannot do anything about administering an asset or an estate in Bulgaria. So you indicated that a will had been made in Bulgaria, and does that will have effect in I think assets in Australia?
Well, I think we've got to the nub of the problem. If I move here,
yes,
and let's say I'm 60, and I've got property worth $4 million in the country I've just left, yes, and I have a will that was prepared there, and it basically divvies up my assets between my dependent children. Let's say one lives where I've just come from and
Yes.
two live in Australia. But I've also got a bunch of money. Some of it's held in US accounts, some of it's held in my former, because a lot of people don't realize, if you're investing in a lot of these big banks, a lot of the money is held somewhere other than where you think it might be.
That's right.
Um,
Yeah.
but I also have cash that I've moved to Australia to prepare for my new life, and I've bought a property here.
Wow.
Now, I mean, but this would be, I would imagine this would be common. Do you need to have a will in both the territories?
Well, so I can give you an example of a matter I've just finalised where a lady had assets she had properties in Greece, and a lot of the time it is properties that are overseas, whether they've inherited them through cultural practices, and they'll have a lot of their cash in Australia. So she had a will nominating her one of her children as executor, and the executor is the person who carries out the wishes. We got probate for her assets in New South Wales, which was cash, and that cash was distributed in accordance with her will, which went equally to her three children. However, she had no will for the properties in Greece, so she was what's known as intestate, meaning having no will in Greece. So her will in New South Wales had absolutely no effect on the distribution of her property in Greece. Now, there's a special thing, because Australia is currently a member of the UK, a Commonwealth. You can probate a will in Australia and have it resealed, which means having it reprobated in another Commonwealth country, such as, say, England, New Zealand, Canada, things like that. Sorry, did you say Italy? What was the last?
No, Fiji. So,
Fiji, because I just want to do a sidebar on a thing called the International Will, which is a treaty that came out, I think, in 2015, where there are certain countries where an international will is recognised. It's got nothing to do with the Commonwealth. But since Greece is not a member of the UK Commonwealth, we could not have that will resealed in Greece. So the laws of intestacy in Greece had to apply. We weren't instructed to follow that through. I'm not quite sure what the laws of intestacy in Greece are. That's where, say, for example, in New South Wales, in most Australian states, it's to the spouse, if there's no spouse, to the children equally, and down the bloodline. But I'm pretty confident, and David, you might be able to help me out. Say in Italy, I think there's a law, like if you die intestate, some must go to the government. I'm not quite sure.
Ooh, it wouldn't surprise me in Italy, Adrian. We're using language here that a lot of people, it might be new language to people. So can we wind it back to some basics where we look at what a will is, and is it something known in other countries by another name?
So a will is a document, and a document is not just paper. It's something that can represent an image. So that could be, at a far stretch, an email or a document on a computer. But for the most part, to make it easy, something that's written on paper. It has to set out what the will maker or the testator wants for how they want their assets to go. I give my car to my son, my house to my daughter, or my cash to my uncle. Just spells out what they want. They have to nominate an executor, and an executor is the person who basically takes charge. And they become the deceased with all the powers that the deceased had during life. The executor has all the powers afterwards, such as funeral arrangements, probating the will, which is the process of proving to the world that this one document is the last will, and then the administration of the estate, making sure the wishes get carried out in accordance with the will. So that's a very simple explanation, and as you can expect, a lot of hiccups can happen along the way. But in essence, a document that sets out how someone wants their assets to be dealt with on their death.
So Adrian, who can make a will in Australia? A lot of our listeners will be wanting to come here, or they'll be temporary residents already here, or some are even permanent residents and citizens. Who can anybody in Australia make a will?
As long as they're over 18 and of sound mind, they can make a will. Yes, minors can make a will in very certain circumstances, but to make this podcast a bit easier, I think for the most part it's adults, it's people over 18 with sound mind.
And how
that rules David and I out. Sorry.
I mean, just basically, because sound mind is a very deep area. How is sound mind ascertained?
Yeah, so that at its absolute, if you want to boil it down to its essence, it's, does the deceased know what they're doing when they are making this document, and do they know the intent of it? Do they understand that by creating this document and signing it, that they have created a document that will form their will, which on their death will disperse their assets, and how that is tested? Well, it's a bit like one of those murder mystery shows, in that it can only be tested after death. So when some people who may have questionable capacity, and there was a case about 5 years ago in New South Wales where a judge made some guidelines, and he said if someone's over 70, it's a good idea to get a contemporaneous medical report from a doctor saying, on the 1st of January 2020, I believe Jane Brown has capacity to know that she's making a will. You don't have to have that, but it's just one more piece of evidence that if capacity is questioned, and as you know, our population age, people are living much longer, and people are accumulating more assets, particularly people born in previous decades, and those assets can be in the millions. We've had tons of matters where, say, a migrant person has bought into Sydney in the 50s, and that property, and they bought into an area that back then was pennies on the dollar. It could be Redfern, inner West Sydney. Wasn't worth much then. Now it's now, and same as Victoria. I'm sure there's suburbs there that in the 50s and 60s they weren't worth a lot, but fast forward 70 years, they're worth a mozza. So the capacity is basically and so if people who are left out of wills, when they were left in earlier wills, might say, well, when that last will was made, they didn't know what they were doing, and then there's a challenge, and there may be no medical evidence whatsoever to help support whether they did or didn't have it. So this area is just becoming larger because people are living longer.
Adrian, that raises. Sorry, David. I want to pick up on that point that Adrian just had about. I was asked to be the executor of one of my relatives' wills, and in that nuclear family, and it was complicated with a second marriage and all that kind of stuff. But there were intense personal feuds within the siblings in that unit, and the relative of mine asked me, and I said, I will only agree to do it if before it's presented to me, so that you have already discussed in the family forum what your wishes are and how you want things to happen. Because I certainly didn't want that bloody bun fight to land in my lap years later, when I might not have had direct contact with any of them for a number of years. And knowing how intense their fights were when they were young, I can only imagine what it might be when there could be, $1 million or $2 being carved up on the table. So would your advice be in general that people should confront contentious issues rather than drop the surprise?
Yeah, absolutely. So I have a lot of people, when the discussion gets to contested wills, they think it's a very prolific issue. It's not really. There are stats that show 98% of wills go through uncontested. There's no challenge made to them. So when people say, why bother make a will? My analogy is, well, there's a 98% chance it is not going to be contested. It's the 2%. It's the green on the roulette table that, the ball landing on the green, which is about 2%, that there's going to be a dispute. But certainly in those matters, you are quite right, Grant. An executor has a thankless job. No one is going to thank them when there's going to be a blue, because you represent the estate and you have to deal with all these fights. And at the end of the day, it's either going to be resolved by consent, by agreement between the parties, or by a judge. And you, as the executor, are going to cop all the flack during it. So it's not something. It's a bit of a, it's not something a friend should put upon another friend if they know it's going to be an issue. Generally, the person with the most to gain from the estate is nominated as the executor, because they have a motivation to make sure it gets done. Whereas, say, Grant, if you were named as the executor of a friend's estate and you were left no provision, you might go, well, I'm not getting anything out of this. I might put it on the go slow. So people should really think hard about who they nominate as executor, and preferably discuss it with them, because it's also a optional job. If you got named as executor and you knew and you attended the funeral and you saw the kids were at each other's necks, and you thought,
the dining room chairs and all the vases out of mum's house.
And you could, before you got into it, you could just say, hey, I'm out of this, and you can renounce. So renunciation is the right of an executor to just say, hey, everyone, I'm out. And then if there's a backup executor, they become the executor. But if there's no executor, then there becomes a big fight as to who will be the executor of the estate. So definitely, it's a conversation worth having.
Adrian?
Last thing I want to say before I'll shut up and let you get through your list, David. Why don't people distribute the assets to the people that they want them distributed to prior to death, if they know that death is approaching?
Well, you can certainly do that. It's called an inter vivos gift, meaning you have given something away prior to death. Now, chattels, which is the legal word for items, that might be a good idea, because often people do argue about who got the porcelain swan and things like that. And so if they're gifted beforehand, that pretty much eliminates the argument. But when we get to big ticket items like property, in New South Wales at least, if you transfer property via a will, there's no stamp duty. But if you transfer a property pre-death, then stamp duty has to be paid. And stamp duty is based on the value of the property. And as you know, Australian properties aren't cheap. So it could be like tens of thousands of dollars. And also if the owner transfers title to someone else, they lose all legal right to that property. So the danger is where people call me and say, I want the bulletproof will. I want a claim-proof will. My
Unicorn.
My answer, and this is in no way legal advice, my answer is, in New South Wales at least, you have to own nothing for 3 years prior to your death. So you've got to live a very monastic life. And why that is because in New South Wales we have what's known as notional estate provisions, which is basically anti-claim preventance provisions. So if you can prove that someone disperse their assets within 3 years prior to death with the intent, like say, Grant, you're my son and I don't want you to get my house. I transfer it to David, who's my son, 2.5 years prior to my death. And I say to you, Grant, you'll never get a cent out of my estate. In New South Wales, at least, you can seek for that property transfer to be reversed.
Yeah,
so it
so
effectively
I'd be
goes,
going, look, smart ass daddy, you can tell me that in 5 months and 30 days, all right?
but if I
And
live
then,
3 years and 1 day, it's off the books. You can't get at it. So the danger, and also the other danger of that is, what if there's a falling out? Let's say I give it to David. I'm living in the house, and David forms a new relationship, and they move in, and new spouse says, "Oh, gee,
we're renovating your room.
it's a bit crowded. Does your dad still have? Does Adrian still have to live in this house? Can't he go somewhere else?" And then I get muscled out of the house that I did own, but I no longer own it. So there is a great danger in giving assets away prior to death, and same with cash, particularly people on the pension. There's a limitation to the amount of cash you can give away. I think it's $10,000 every 3 years before your pension gets affected. So the government have put all these. Of course, you can make your will to who you want and leave it to who you want, but the government has put all these little provisos in to try and minimise people doing that without penalty.
Adrian, what can you leave in a will? I mean, property, cash. What are some of the other things that people listening would want to contemplate leaving in a will?
You can leave any and everything you own. You can leave in a will, but you must own it. That's the thing. But what a lot of people don't know is, say, property and bank accounts can be held by more than one person. So in Australia, we have what's known as joint ownership and tenants in common. And a lot of people don't know how they own their property. So a lot of married couples own real estate jointly. And what that means is they both together own that house. And if one of them dies, just by the mere manner by which it's held on the land titles office, so say if me and my wife, we own a house jointly. If I die, my share automatically passes to her. Doesn't matter what my will says. Same with a joint bank account. It goes straight to them. So I might write in my will, I want my house to go to David. But if I own it jointly, that provision in my will means nothing. Same as a bank account. So if you own it, you can leave it to someone. So basically it's property, so real estate, cash, shares. Superannuation is very difficult. Well, it can be difficult because superannuation doesn't generally form part of your estate, nor does life insurance. Chattels, so things you own, cars, boats, things of that nature, items around the home, you can leave that. Yeah, pretty much anything that you own.
Have you had anybody try and slip things in? Go on.
Just the concept of ownership too. A lot of people will be in the situation where they own a car along with a finance company, or they own a house along with the 60% that the bank owns. So to pass on a house that has an encumbrance of, let's say, 60%, which might be common if you die in your late 40s or 50s, for someone to inherit that house, they actually need the means, or the estate has to have the means to settle the mortgage, don't they?
Well, no. If you give a gift and if it's got a debt on it, the estate doesn't have to meet that debt. So Grant, if I leave you a house worth $1 million, but it's got $900,000 debt on it, and say I've got $1 million in cash in the bank as well, the estate doesn't have to make up that debt to give you an unencumbered mortgage-free home. You would get the title of that property, but have you ever heard of a bank Have you ever heard
and
of
a
a bank
mortgage.
losing out? They never lose out. So
I guess the point of that example is, if I'm say it's the the parents in their 40s or 50s, and they bought the house when they perhaps migrated to Australia when they were 21, and they bought, like we used before, a home that had very little value in terms of the real estate market at that time. But then by the time they've died, it's worth a lot. But over that time, all of Dad's financial advisors have been saying, you can borrow against this property. Did you know that?
Yeah.
And we've had 10 trips around the world, and all of a sudden, so they got a massive mortgage on it. Now, if I, as the son, am a university student who can't service the mortgage, I don't get the house, do I?
No, and that's a big trap with these reverse mortgages. They sound nice, but the interest rates are prohibitive, and so to borrow 10 grand, it might end up being, I don't know, 50 down the track. But yeah, you if you've got the means to pay out the mortgage, then yeah, you get the title. But if you can't, the house will be sold. Bank always gets their cut.
But if Dad had mortgage insurance, does that pay out the mortgage?
I don't think so. Isn't mortgage insurance for if you default, the bank is protected? I don't think it pays out.
Well, that's why I raised it, because sometimes you hear people say, "Oh, no worries, there's mortgage insurance and all that." But the simple fact is, if you inherit a house or any asset, you inherit Dad's yacht, but you can't afford to service what's still owing on it. It's got to be sold to settle the mortgage.
That's right. Yeah. I'm pretty sure from the last time I had anything to do with mortgage insurance was buying my place 20 years ago. And from memory, I think it's if you're borrowing more than 80 or 90%, then that insurance is there for if you stop paying, and you cannot, and the property gets sold, and the property is not realised,
and the bank
for
loses
less than what it's currently valued at, which has happened. Which say like in COVID, if they've been talking about property prices are dropping, the bank gets protected. It doesn't help the purchaser or the survivor.
Yeah, that's all I wanted to point out, because people watch. I mean, we've been watching for years movies and TV shows with all these outlandish things that happen with wills. Admittedly, most of them are in Fantasyland, USA, or whatever. But the simple fact is, whoever is owed money gets money before anyone else gets it.
Well, absolutely, and that's very important and Grant, as when you said about being an executor. So I make a series of videos that I put on our website, and one of them is how to not get sued as an executor. So can you imagine being lumbered with being an executor, and you do one thing wrong, and you personally are held accountable? Yeah. Yep. So Grant, if you did not bother to properly advertise that you were getting probate of a will, and you just go ahead and you distribute, there's a bank account, there's 100 grand, I'll just distribute it to the kids. And then 6 months down the track, Westpac send you a letter saying, "Oh, hello, Grant, we understand you're the executor. The deceased owed $200,000 to Westpac. Could you fix that up?" Yeah. If you've distributed the estate, guess who now personally owes Westpac? You do. So an executor is not a role you just take on lightly. It's and why we recommend you get a lawyer to help you administer the estate. Some people do it themselves, but you get one thing wrong. Banks, as you know, banks don't like not getting paid. They will go to the ends to get their money.
Yeah, they'll spend 100 grand to get 15 grand back.
Would be. Well, if you've got property, if you own a house and you say, "Hey, no, well, that's my house. That's not the deceased's house." They say, "Well, under this piece of law, the Succession Act in New South Wales, it says you're only protected as an executor if you properly advertise on the internet that you're getting probate and you've waited a certain period of time since death, 6 months. A period of time has passed since you've advertised, and there's no claims on the estate. then you can safely distribute. But if you miss any one of those things, debtors can come and get you and get your money.
I've just redone my will, and what the lawyer asked was what I wanted to do with my social media accounts. Now, what are some of I thought that was rather interesting. What are some of the things that people like social media accounts? What are some of the more exotic things that you've seen people want to have in their will allocated to family or friends? What are some of the that they have owned? Any stories, any examples?
Well, you can all, when you leave, just as you can not be an executor if you choose not to be one, you can also choose not to be a beneficiary. So if you've been David, if I leave you my yacht berthed at the Lake Macquarie Yacht Club, and it's got berthing fees of $10,000 a year, and it's got rust all through it, and like you might think, like, what the hell do I want this for? You can say to the executor, I don't want this. And I have seen instances where people have been left these assets that were very important to the deceased, but of absolutely no interest to the beneficiary. And they say to the executor, I don't want it, you keep it. So nothing unusual, unfortunately, comes to mind that I think of people that I've dealt with. So generally, it's the funds that people are more. No one's ever knocked back money that I'm aware of. But yeah, like social media accounts, yeah, like your Facebook and co are very protective of not releasing passwords. So that's something that people have got, like, God, everyone's got some kind of electronic, like whether it's a Gmail account, which might be the key to all their finances. Like everything they have is held and registered via a Yahoo account or a Hotmail account, which has a password, which if you're the executor and you write to Gmail and say, oh, I'm the executor, can I have the deceased password? They'll say no. But if there's some measures in place, they might be inclined to give it to you if the will specifically spells that out. I've not drafted one that includes that, but certainly it's a discussion that, as you say, as the laws evolve, definitely worth considering.
You had earlier in the podcast, you made mention of the Greek lady who had her affairs catered for here, but not in Greece. Would she have been better served to have a will here, considering her assets in Greece, or would it have been better for her to have two wills, one for each jurisdiction?
In that situation, because there's no treaty, there is. I'd have to look it up, and it'd take me only a few minutes. It's the International Law Treaty, of which there's only about 10 countries that are signatory to it. Australia, I think India, UK, America. You can make a will here, and it can be valid in those other countries. And now, from last glance, I'm not sure if Greece was one of them. But there's many, I think there's about 250 countries, and I think there was only about 10 or 15 signatories to this agreement. So there's a high likelihood it's not going to be worth anything in Greece. So she should have, and why it's much better to have a will rather than go through intestacy, even if she was fine with her estate going equally to her children. If a will says I leave everything to my three children, then that's it. There's no misinterpretation about that. But under intestacy, the person who has to make the application has to jump through all these hoops to satisfy that there's no other categories of relative that would benefit. So the executor the administrator who would likely be one of her children would have to prove that she didn't have a spouse, that she didn't have a de facto, that which doing these activities in Australia, in Greece, you would likely have to hire a lawyer in Greece to conduct all these searches, to go through the Greek birth, deaths and marriages, to evidence that her spouse had died, affidavits done that she didn't have a de facto. all these unnecessary tasks. Like, the job will get done, but it will be vastly more expensive than had she just made a will that was valid in Greece for her Greece assets.
When I ask clients a lot about wills because they're a very powerful piece of evidence for a partner visa, for example, what I hear a lot when I ask a client or a prospect if they have a will is, I'm too young to have a will. I don't own anything to have a will. I don't have a partner to allocate to distribute to. I mean, can you be too young, too impecunious, and too single to have a will or not have a will?
No, absolutely not. And particularly, as you've indicated, David, a lot of the people who you act and advise for are people who come to Australia with the intent to work, whether it be a temporary visa or anything. If they work in Australia, generally they would have a right to superannuation, as I understand would be the case. And with most superannuation policies, built in within it are insurance, such as death benefit policies. So if you die on the job, your estate gets paid. Generally, it's about $500,000, so $500,000. And if you haven't got a will, and it could be very problematic who gets that money. So we've had situations where, say, a young boy, his dad vanished when he was a baby, raised solely by his mother, got a job, unfortunately died in a work accident at 19. He got the death benefit of $500,000. It was paid to his estate, and under intestacy, since he had no will, intestacy laws in New South Wales go spouse, children, parents equally. So that $500,000 passed equally to his mother and his father. So his father he'd never met, didn't even know who he was. So his mother, who was living a hard knock life, raising him, was going to just get half of that $500,000, so $250,000, and his dad was going to get a windfall of $250,000. And same with, say if there's a de facto in New South Wales, and I'm not sure what is outside of other states, to benefit as a de facto, you have to be together for 2 years, as in a continuous resident, like together for 2 years. And all you got to do is fall short by 1 month. You don't tick that box, you get passed over, and then you've got to do.
Is that cohabitation? 2 years of cohabitation, non-stop lineal cohabitation?
Pretty much, yeah. So you've got to show that you were a de facto. So, and to establish your de facto, you've then got to go down the rabbit hole of the Interpretations Act, Section 21C, which has about 8 different criteria that helps a court determine if you are a de facto couple. And the analogy I use, and it's a video I've got, is proving that you're a duck. If it looks like a duck, if it has wings and feathers, if it flies south for the winter, it may not know it's a duck, but everyone else says, yes, that is. So if you are a couple that share finances, if you have children together, if you have a sexual relationship, if you live together, you've got a public perception that you're in a couple, a judge will say, yeah, you're a de facto couple. So you've got to establish that for 2 years. But if you had a will that just said, I leave it to Jane, and Jane was your partner, you wouldn't have to jump through. She would, as your surviving beneficiary, would not have to jump through all those intestacy hoops to warrant to the court that she's the de facto under intestacy. So just these little slips of paper, which are just like one A4 piece of paper that says, this is my will, I leave my assets to X, can save countless thousands of dollars and months, possibly years, in getting to what the survivors believe to be was the deceased's aim.
But a simple will of that nature is still very dangerous.
Yes.
What I do see a bit of, and I don't practice in the area, but love to hear your thoughts on will kits and the new trend of artificial intelligence website-generated wills. What are your thoughts on those?
Yeah. Do-it-yourself will kits are great for the prosperity of contested estate lawyers, because they are so open for, pulling apart. And I have seen many of them, and it's for 29. My philosophy is you've got to be very wealthy to make a cheap will, and the reason for that is generally they're handwritten. The handwriting's often not the neatest, and just having it not neat handwriting, it could be construed that the deceased didn't have capacity. The witnesses to the will. So for a will to be valid, it has to be a document. It has to be signed by the will maker, and it has to be witnessed by two independent people who have no benefit in the will. And generally that's a neighbour or a stranger, or a stranger to the survivors who may not be located after they die. And generally to probate a will, there has to be, it certainly helps to have attesting witness affidavits to say, I witnessed David or Grant sign this document and on this day. But if those people have disappeared or don't know where they are because they didn't write their address or their name's illegible, it just adds one more layer of, hey, is this document really what the deceased wanted, or has it just been something that's been shoved in front of them by the caring neighbour or the carer to go, oh, of course she wanted to leave everything to me. I looked after her. So they're good. They're okay if someone has a very simple, uncomplicated relationship arrangement. So if it's a nuclear family where, husband, wife, children, and no one else, and you want to leave everything to your spouse, and if they predecease to your children equally, it might do the job. But all there has to be is one thing wrong with it, or someone who's missed out say, hey, this will's a sham, and that 29.95 will becomes a many tens of thousands of dollars of legal costs in a 1 week hearing in the Supreme Court as to, was this the document the deceased intended? So, and as to the AI wills, yes, and also with that, no advice is given. When you get a do-it-yourself will kit, no one's going to ask you, do you know what assets you own? So if I was doing a will for someone, I'd say, David, do you own any property? And you'd say, oh yeah, I've got a house here. Okay. Do you know how it's owned? I recommend you do a property search to make sure you actually own it in the means by which you understand it. Because if it's jointly owned and you leave it to Grant, that gift is not effective, and just doing that alone might undo every other term of that will. A bank account, you might not know. You might think you're leaving $1 million in cash to someone, but that account may have no money in it. Because of the way you've worded it. And I've seen the most bizarre do-it-yourself wills they have great benefit to contested estate lawyers. I would not recommend people do them for their own benefit.
Adrian, what about loopy conditions? Like when I die, I don't want to be buried. I don't want to be cremated. I want to be taken to the ice works where they have a dry ice facility. I want to be snap frozen, and then I want to be taken down to the golf course, and all of my golfing buddies can smash me to pieces.
Wow, that's creative. I like it.
Just came to me.
That's
just
good.
came to me.
Yep.
Can they be enforced?
Well, the executor. So the executor is the person you trust wholly. So your executor should be someone you trust completely to carry out your wishes. Now,
I hope you're taking note, David.
Now, the primary role is to carry out those wishes, but they have to be reasonable. And if they're not to the benefit of the beneficiaries, the executor can veto those wishes. So that situation, if it was cheap, if it was inexpensive, and it was not, and your surviving family members didn't object and didn't think it was an imposition of your dignity, David theoretically could do it. I've not heard of it being done. The only main ways you can get buried in Australia is through burial and cremation. I've not heard of cryovac freezing and smashing, but there's another way. When I was looking up this, there's a way. It's deemed cremation, but it's water cremation, where your body is put in this vat with chemicals and it's dissolved, and that's legal in New South Wales, but no one really does it. It's and the state waterway, and the state waterways won't let you put the remains in the sewage system. So that's a way you could get dissolved in this. I think it's called alkaline hydrolysis. So you could get made liquid and then frozen, and then take it down to the Gulf Coast. But if David didn't want to do that, he wouldn't have to. He can say, "Yep, great idea, Grant, but I think you're going to get the standard cremation or a burial process." So it's people don't know. A lot of people don't know that the executor can veto the deceased's wishes when it comes to burial.
And what about the kind of outlandish punitive clause? Let's say I have one major asset, and it's an extremely rare book, and it's worth $750,000, and my children, I don't like them very much. I don't like the way they fight very much. So I have a special clause in my will that says, in the event of my death, my executor, Mr. Bongiorno, is to take the book and ceremoniously burn it at a barbecue, and he will invite everyone in the family and everyone in my street.
Well, I would expect to get a phone call from one of your children asking for a immediate injunction to be placed on David to stop that happening. And if he did it, I would seek an order that he be held personally accountable to restore the estate of the equivalent dollar value. So yes, you can say it, and yes, you can put it in there. Though David, as your executor, would want to get some very good legal advice on following through with your wishes. So basically, you can say whatever you want in your will, but if it's an affront to, if it's illegal, the executor can't carry through with it, or if it's an offense, if it's an affront to public policy. So if it's something that might be, racist or in contrary to the current morals of the day, it shouldn't be followed through with.
And you also made the point that it shouldn't disadvantage the beneficiaries. So I guess my outlandish point is that
do it before you die. Do it before you die.
Yeah, that's right. So you've got to deal with the opprobrium of your family rather than leave it to some other sucker. If you want to be a nasty bugger, you really should do it before you die. Because a lot of these crazy examples that we hear about in wills really don't have any effect if the executor doesn't want them to.
That's right, because the you can do, Grant, David, me, if you want to put all your assets in a pile and burn it to cinders, completely up to you. Empty it all out before you die, give it away, join the ski club, spend it all, that's on you. On your death, your executor can't just say, "Oh, well, it's what Grant wanted," or "It's what David wanted." You've got then a responsibility to the beneficiaries, who won't thank you for burning your $750,000 book.
Adrian, a couple of scenarios for people listening.
Realistic scenarios.
Realistic scenarios.
It doesn't matter. I've seen amazing stuff, so it doesn't have to be.
A Pakistani grandma comes to see her son and daughter-in-law and grandchildren. She's here for 3 months. She's early 70s. Does she need a will, an Australian will?
Well, I'm presuming, for the sake of the discussion, that she may have assets in Pakistan.
Absolutely.
And from memory, Pakistan is a signatory to the international will. So if she had a if she had a will in Pakistan, it could be equally applied in Australia from memory. But let's say she was from a country that wasn't a signatory to it, and she died and she was here. So yeah, if she's here and goes back in 3 months, no problem. But no one knows what's going to happen tomorrow to the next minute. Presume that she does die, or presume she comes here, COVID strikes, she can't get on a plane for the next who knows what, so she's stuck here.
Correct.
And she doesn't make a will in that time, and let's say she dies of whatever means. Now, if she has accumulated no assets in Australia, shouldn't really be a problem. But what say if she has, if she bought a scratch ticket and won the lottery, or by some means had gained assets in Australia? How would those assets be applied? How could her administrator, who would have to be, since she died intestate, it would likely be her spouse, and if she's got a spouse back in Pakistan, they would have great difficulty. They would have to get, because you have to be a resident of the state to get probate as an executor. So if she's got a husband in Pakistan, he wouldn't be able to get letters of administration, which is what you have to do if someone has no will, from Pakistan in Australia. He would likely have to get someone such as me, and I've done this year. I would have to be his power of attorney to do all the activity, to get letters of administration, and then in order to administer the assets she had gained in Australia. She might buy a house while she's here. That's not. She might get a job, and in getting that job, might get super. All those things that are unknown and unknowable as to when she might die. So yes, she could play the odds, not get one. If she goes back, so if you go on a holiday for 3 months, the last thing you'd think of is making a will in that country. But COVID, like David and Grant, I'm sure you've got the finger on the pulse more than I do about people who have come here and can't go, and people who have left Australia and can't come back.
Absolutely. Daily problem. It's a very, very challenging environment. I'll throw another scenario. A lot of people come here and study and they work, so they accrue super, and they might buy a car. If they partner up with somebody on a de facto or registered relationship, or marry, that's a good reason to change a will. The introduction of somebody else into the equation is always a good reason to get a new will, correct? If
Absolutely.
there's a new boyfriend, girlfriend. What are the other life changer events where you need to consider changing your will apart from a new partner?
We recommend, and it's not like lawyers don't make any money out of making wills, out of simple wills. They're like $200, $300, $400. It's not big. It's not big income. But so it's more of a public service to say, we recommend you update them regularly, because you might, like I've got a 13-year-old and a 10-year-old, which in that time's just flown. I've just blinks, and time passes so quickly. But when you have a major, so we say every 3 years, just out of habit. But yeah, if you partner up and someone, de facto, you may not, as that example I gave, you may not know or appreciate that you're in a de facto relationship, but you move in, automatically you've got a legal spouse if you tick the boxes. If you get married, in New South Wales at least, marriage revokes all previous wills. So if I want to leave everything equally to David and Grant, and I get married, and I think, oh yeah, my future wife, she's loaded. She doesn't. I don't need to make a new will, because she'll keep what she's got, and I'm very confident that David and Grant are going to get what I have left them. By the mere act of that legal act of marriage revokes all previous wills. So if I then die, I die intestate. Who benefits? My spouse. So everything I intended to leave Grant and David goes to my spouse. And I might not have even intended for that to happen. it just happened because I got married. If I get divorced in New South Wales, all gifts and allocations of appointment, such as executor, to my ex cease. So if I left a house to my ex, that gift voids and it goes into what's known as residue, or so that gift gets dealt with under the residue clauses of my will, and I might not want my residual beneficiaries to benefit under that future event. So my residue might be to my my second cousins twice removed because I've only got a small bank account, but that major asset that was left to my then wife that then falls into residue, I never wanted them to get that. But that's why it's worth updating your will, because your estate can be left in a manner that you do not want to happen.
Last question from me, Adrian. Conscientious young person, studies, gets temporary residency, gets permanent residency, takes out a will, and then does nothing. And 70 years later, 60 years later, oh, my will, where is it? Where's the practitioner? I can't remember who took my instructions. What happens when a will is lost in the system, for want of a better term?
Yeah, lost wills happen quite a bit. People just make them. They do a set and forget, and it could be with their lawyer from in the 80s. That lawyer retires. Who knows where that lawyer's documents have ended up? They might have been burnt. Who knows? And tracking it down, if proving a lost will case, which I've done a few of them, it's very hard. You've got to prove a hell of a lot of things. There's a presumption that if the deceased was the last person to be in to hold the will and it can't be found, it's presumed that they destroyed it with the intent of revoking it. But if the evidence is, oh, I gave it to David Bongiorno to look after, and that's the last I knew of it, then we've got to get a statement from David. We've got to get, does he have it? Does he have a memory of it? Does he have a copy of it? If he doesn't have a copy, does he recall what it said? If he can't recall what it said, what is it likely to have said? All these very complicated things, which, and a contested estate claim, if it can go for days, and they're not cheap. These cases are not cheap. That's just the way it is, because you've got barristers on both sides, you've got lawyers, you've got transcript fees, you've got filing fees, you've got daily hearing fees, all for the want of someone. You can register your will with the court. I'm not aware of anyone practically does it, but leaving it with a lawyer who you know is not going to retire soon, and letting family members know who has it is a great idea. So let your spouse know, let your kids know, I've left it at Turnbull Hill lawyers, they've got it. So when the time comes, if someone dies, they just call them. We've got a big steel room full of wills from the past 50 years. It's a fireproof room, alphabetized and categorized. So when the time comes, we can just pull it straight out. But if you've shoved it in a drawer, then there's tons of cases about that. The Brett Whiteley, famous Australian painter, he had a will which he showed his, I think, then son-in-law. It's hidden. I've sticky taped it in the underside of this fourth drawer. And then when he died, that's useful. A bloke who's worth tens of millions of dollars. And it seems to be the richer you are, the more, and celebrity, the more likely you're not to have a will. I think Pavarotti, Prince, Michael Jackson, there's tons of celebrities who are worth absolute millions, just never get around to it. And so then there's cases that go for years. But let it be known where your will is. Good idea.
Adrian, you've been fantastic, mate. Thank you for taking Saturday afternoon. Oh, I forgot.
Hang on.
There's always one question or two from Grant.
I haven't had the opportunity of the last question, and and I want it to be consistent with my theme for the day, because we've been dealing with a difficult topic, and it can be hard. Adrian, what's the most bizarre or the meanest thing that you've seen in a will?
Ooh. This one was mean, and it was overturned. It was, if my daughter marries this person, and this is a case we ran, if my daughter marries a person of this race, she's excluded.
Jeez.
And she did, and there was a case about whether that provision should be upheld. Of course, we succeeded because it was an affront to public policy. And she also had what's known as a family provision case. But yeah, people can do some really. I had one where a mother overlooked, so a daughter overlooked inviting her mother to her 6-year-old's birthday until 3 days before the date, because she was just caught up in doing other things, and the mother took great personal offence to that, wrote her out of the will, and she died a few months later. And so that led to a case. It doesn't. A lot of the cases we run, you're not seeing humans at their finest, generous element. But that's human nature.
And what about Michael Jackson Bizarro Crazy? Anything in that league?
Well, Prince didn't leave a will, but he didn't marry, and he didn't have any surviving children. So he had, I think, 6 half siblings, and in New South Wales, at least half siblings are deemed siblings. So that all went by intestacy, and he was very protective of his musical copyright. You would never see any of his songs on YouTube or anything where it could be freely accessed. Within a few months of probate being granted, because there's he wasn't motivated by a dollar because he had heaps. But his then executors could use his image however they wanted, use his music however they wanted. But the celebrities have got some. I think Pavarotti had a few past lovers.
Yeah, he had 150 unknown children, didn't he?
Yeah, that's right. That's why it's the children that's it. It's the children that crop up who say. I think in Sydney there's a fellow who owns all the nightclubs. His name was Hems. His son is Justin Hems, and he inherited everything, but he had a child from a one-nighter, but denied parentage. And it was proven that this son was his child, and he had nothing to do with him. I think he got about $1.5 million from his estate. But that's something we haven't covered on today, which is the predominant area I do, what's known as family provision, where yes, you can make a will leaving what you want to who you want, but if you don't include what is known as eligible persons, which is generally spouses and children, and it can be adult children, they can claim upon the estate for provision, and that's quite rife.
We'll get you back to talk about that in 6 months' time.
Yeah.
What do you reckon?
Yeah, that would be fantastic. Great.
Love to have you. Adrian, can you do Grant and I a favour, mate? We're in lockdown. Can you take a walk on the beautiful Newcastle beach for us? We're nowhere near beach at the moment. We're locked in. We're locked in and locked down.
St Kilda's off limits?
About 8 k's away. We can't do it. Grant's about 10, 15 k's from the beach. I'm about 10, 15 k's from the beach. You've got to be within a stone's throw, surely.
I am just within 5 k's of the Pacific Ocean. As the crow flies, I'd be about 1 k. So
I'll have a walk in the swim for us. We're jealous, mate. All right.
Yeah, I will. Get out there.
Well done, David. You've just lifted the property values of my neighbourhood very significantly. Oh, to wish I was 15 kilometres from the beach.
Adrian, have a good Saturday afternoon, mate.
Yeah, you too. Great.
Thanks for coming.
Thanks, Grant.
Ciao.
Adrian, before you jump off, you just tell everybody where they can access your resources.
If you just Google there's a video series I run called Battle of Wills. So if you just Google battleofwills.com.au, I'm very active on LinkedIn. That's how I met David, and I'm very pleased I have. We share a lot of music, other interests.
We're men of excellent taste. We've got
That's right.
mutual, that's it. That's
Robert
it.
De Niro. But how could you? Inspector Montalbano. How could you go past these places?
I did watch your videos this morning. They're very good. They're very good.
I try and do it about 2 to 3 minutes of. I try and give it to a lay audience.
Yeah,
in a way. I hope in a way that's not too dry, because a lot of it is they are a dry subject, but this is I find it a very interesting area. It's full of a lot of passions and drama. So I try and discuss these matters in a way that would relate to the common person. But yeah, Battle of the Wilds. Yeah. So thanks, David. But please connect with me on LinkedIn or go to the YouTube channel. I'd be very welcome to discuss any issue with anyone.
Beautiful, Adrian. Thank you.
And if you'd like to see a podcast series of the most bizarre and crazy examples of will conditions featuring Adrian, I think
I'd have to say the names have been changed to protect the guilty or something like that.
Exactly. You never have to directly put people up for public ridicule, but it's always good to know the crazy things that your fellow humans get up to.
Yeah, that's right. Fantastic.
Well, thank you very much, Adrian Corbold. David Bongiorno, the migration titan. Of course, David, people can look you up on Twitter at David Bongiorno and Instagram with the same handle. And if you want to catch up with me, you're going to have to look in the links, the links down below, as we say, the episode links, and you can talk to me about a podcast if that's what you would like to do.
Great.
Thanks, everyone.
Have a great day, gentlemen. Ciao, guys. Ciao.
Ciao.